Thank you. This pretrial review is in the matter of case number CFI 056-2022 before His Excellency Deputy Chief Justice Ali Al-Madhani. The claimant is represented by Norhan Abdul Latif Saabi advocates and legal consultants. Lead counsel is Ms. Maryam Razzaq. The defendant is represented by MB Kemp LLP. Lead counsel is Mr. Salah Moto.
Yes, good to see you,
Your Excellency.
Mr. Razak and Mr. Mato.
Nice to see you too,
Your Excellency. The parties have submitted the checklists, and parties are in agreement instead of a 2-day hearing to have a 1-day hearing because the timetable fits in well for a 1-day hearing. The parties have also discussed timetable but have not reached an agreement on the timetable. So that's the only matter that we have outstanding between us pre-trial.
Well, I guess I have seen that. I've seen your proposal. I mean, it's before me. I had looked at it before this meeting. And yes, I have seen that.
What is put in
you're moving toward
Your
1-day trial.
Excellency.
Hello, you hear me?
Yes, Your Excellency, because our discussions with the claimant, both sides feel that 1 day will be sufficient, given that we don't really have a whole load of material to go through, and we should be able to assist the court to finish the trial in 1 day.
Well, let's see. It's at one hand, it's really good things to do, but on the other hand, I can see from my experience some difficulties. Having 3 witnesses into the courtroom in 1 day is not a straightforward thing, to be honest. This is, I said, it depends on the amount of facts, the number of questions, of the length of the cross-examination. But usually 3 witnesses a day can be exhaustive, save for the opening statement and then closing statement, where the closing statement is the most important element for me. Unless you abandon that and you will go toward, let's say, a written closing statement. So that then if there is a written closing statement instead of oral one, then the accommodation of 3 witnesses might be sort of easy things to do.
Your Excellency,
What's your view?
Can I take a few minutes just to take instructions from those instructing me?
Yes, Mr. Razak, yeah.
Thank you.
Your Excellency, I already have instructions on this point. The defendant's position is that written closing submission should be fine for us.
Okay, you prefer, okay.
Just bear with me, Your Excellency.
Take your time. I mean, I will discuss another matter with Mr. Mato. Mr. Mato, are we expecting parties to attend the hearing in physical?
Your Excellency, our preference would be virtual hearing, and that's
you're Dubai-based, yeah? You're Dubai-based firm, yeah?
No, I'm based in London.
Yourself, okay.
Yes.
Why didn't you come? Why didn't you make it to Dubai so we can see you here in our courtroom?
Your Excellency, I'm in Dubai every 6 weeks. It's for this particular hearing, we have a hearing right after this hearing on the week after in Geneva. So that's one of the reasons being in Europe would be preferential for us. And my learned friend, Ms. Razak, is also based in UK.
I say both of you. So coming to Dubai you're going to incur sort of cost, isn't it?
As a matter of course, as well, Your Excellency, I'm usually in Dubai every 6 weeks. But
why this week? Why not this week then?
Your Excellency, we have another hearing before you, and hopefully we'll do that in person. I think in sometime in June we have a hearing.
Oh, yes, yeah,
Listen, in front of you.
Yeah, so that would be one of the 6 weeks in Dubai, isn't it?
That's correct. But the idea is to be in Dubai every 3 to 4 weeks now. Your Excellency, the amount of work we are doing is significant. Now we have a very very big Dubai Abu Dhabi office. So we are growing. So in that sense, we are growing with Dubai, as they say.
Well, congratulations, congratulations. And
Your
I
Excellency.
would like to ask you, if, in case you cannot attend. I mean, well, I have looked at the background of this case, and I've seen the determining factor was that, correct me if I'm wrong, the agreement that reached between the claimant and the bank. The defendant says it's containing a kind of a precedent condition. And unless that is met, and then the condition is not sanctioned or fulfilled or whatever. So this is, let's say, a sort of a legal discussion, maybe, you know what I mean? Why do we have, I said, I'm not aware of the full case. I have not prepared it for trial, but from that basis, are we expecting the witnesses to say a lot about it?
Your Excellency, you're absolutely correct. From the perspective of the defendant, this matter concerns interpretation of the contract more than, and it's a legal interpretation of the contract. And there's a limited help we can get from the witnesses because it's the four corners of the contract that we will be arguing on. At the most, we say that the witnesses will provide some understanding of what was the intention of the parties when they entered into these contracts vis-a-vis payment of the success fee. So that's why we say that a limited with cross-examination should be sufficient. And that's why one-day hearing would be appropriate if it assists Your Excellency. Perhaps in our opening statement, we can put some legal submissions to you as well on the interpretation of the contract.
Yeah, because I really thought it's really an important point. That's why I just
Yes,
put
I
it before
agree.
you. You can address it at the beginning maybe, and
Yes,
we
that's correct.
fully, Your Excellency, yeah, correct, and we take Your Excellency's points on board, and I think that would help the parties narrow the issues, which is essentially, as we say, interpretation of contract, and hence Your Excellency is also correct that written submissions might be better for closing, so that we can develop legal points based on testimony, so that it can assist you in reaching a judgment on the matter.
Your Excellency, I now have instructions. Closing statements are absolutely fine.
Okay, so that's good. You know what would happen? I mean, if we make any progress during the trial, like if the witnesses, of fact, did not elaborate much on the agreement, so let's say if we grapple with the witness cross-examination in a good timing, so I might relax the parties. So you might say something, I mean, if you wish, toward the end of trial as closing submission, or you might just completely reserve for a written submission. I think we
Your
would
Excellency,
be
we will be
flexible.
guided
Yeah.
by you. We will be guided
Yeah.
by your directions during the trial, and we should be open, and your judgment on these matters will be fine for the defendant. And I'm sure my learned friend would agree with
Yes, I
my
totally
position on
agree,
that.
Your Excellency.
Yeah, that's how, because I'm expecting usually the closing submission will not take less than 45 minutes at the best
Yes.
scenario, and that's make it 1.5 hours. And I don't think we have it, and at least within the current schedule, I guess, that we do have. But I said, if there is time, if there is room, we can accommodate both. So we can discuss even how you will deal with costs, even in whether you deal with costs during your written submission or maybe later after myself handing down the judgment.
Yes, Your Excellency.
I do have another question then. Have parties, I mean, finished with exchanging evidence, witness statement, and everything? You're ready to
Yes, we're ready, Your
go to
Excellency.
skeleton arguments?
Yes, we are ready.
Yes, yes, Your Excellency, we have. We for your just for your refresher, we have gone through disclosure. Then we had the witness evidence exchanged, and there's no outstanding matters concerning any of the orders of the court, and we are ready for the trial for skeleton arguments to be lodged. Bundles are, with the new technology we have in DIFC courts, we can readily convert this bundle into a trial bundle after this hearing.
That's it. Yeah.
And as a feedback, this new system is very, very good. So we're very happy to have this this technological
Especially
change.
the pagination, Your Excellency, it's great.
Okay, well,
Yes.
I'm glad you like it. Yes, yeah.
Yes.
This is, we've been working in this. I mean, recently to develop this new case management bundle or like e-bundle, whatever called.
Yes, it
In
makes
fact,
it much easier.
Your Excellency, I've mentioned this. I'm part of this High Court committee in London, and we have a really, really archaic electronic system. So I have requested them to have a look at DIFC courts as an example.
So you're the expert.
To update.
You're the expert.
Your Excellency,
yeah, if a compliment come from an expert, it means it's really working. So
no,
yeah,
it is very
Mr.
sophisticated. It is perhaps the best bundle system that I've seen, and it's very user friendly. It's very easy, and it's very easy to search within the bundle as well. So, so in that sense, it's very, very helpful and can be done very quickly. And what it is very unique thing about this is, if we have to create a trial bundle out of the PTR bundle, all we need to do is just update this bundle, not make the bundle right away afresh.
Oh, a new one, yes.
So
yes,
so it saves a lot of time.
Well, that's it. I'm really glad to hear that. So this is all for you anyway, at the end of the day. I mean, to just, this is to allow you to present the case easily, fairly.
Next step is we will agree to a tentative schedule between the parties that with your directions during the trial, we can basically move up and down. I think we should be able to, with written closings now being decided, be able to do this within a day, and we can keep the 25th in reserve should we need it. But if not, we should be fine, I think. And again, on behalf of my learned friend, and I would like to also thank you, Your Excellency, for your directions today and for your feedback.
Thank you, Your Excellency. It's highly appreciated.
Thanks to you. Eventually, I would keep half day, I mean, reserve. We never know, because having 3 witnesses sometimes it's, as I said, complicated. I mean, from my experience, dealing with 3 witnesses in one day is not an easy thing to do. But I would eventually have at least 3 hours for the next day, in case things happen, or in case you change your mind, you will deliver oral submission.
Thank you, Your Excellency.
Thank you, Your Excellency.
To get judgment faster.
We are very, very grateful for your experience and for your help, Your Excellency. Thank you.
Thank you very much. Thanks for appearing today.
Thank you, Your
see you
Excellency.
soon.
We look forward to seeing you in person.
The only issue that we have, Your Excellency, is with regards to the order. If I can address this with you, do you have the email sent to you at 12:53?
Yes, I do have it.
Yes. So the only issue I wish to raise on that point, which I have instructions for, Your Excellency, is the order of cross-examination of the claimants. So the defendant is to cross-examine Mr. Abdul Muiz Khan during the duration of 10:40 to 12 p.m. It's the claimant's submission that instead Mr. Adnan Farouk is replaced at this time, as Mr. Adnan Farouk had the majority of dealings with the defendant, and that Mr. Abdul Muiz Khan is replaced at the duration of 12:15 to 1:05 p.m.
I didn't see any issue with that. I
Your
can
Excellency,
accommodate
we
that.
don't have an issue with the order of the witnesses, but all we say is that we be given more time if we need to cross-examine the witnesses. We don't have any issue with the order of the witnesses, but to restrict us based on what the my learned friend says, that who had more involvement in this matter, it's matter of disagreement between the parties. So all we say is that we be given extra time if we need to cross-examine the second witness in comparison to the first witness.
Yeah, as we have now we have stretched our day now by moving to closing submission or having a spare day for the next. See, as you said, order is not problematic, and then even the allocation of timing. If you want to keep the same order, but if you want to give the second witnesses more timing, that's fine with me. If you want to replace the witness, you take one. So when it comes to cross-examination, I would prefer like the defendant can choose which witness can take first, and maybe which witness they can take second, and then the time can be allocated, I mean, proportionally between both of them.
Yes, Your Excellency, I totally agree. As long as the proportionality is equal, I have no objections to that.
I think I think we don't have an issue then.
Thank you, Your Excellency.
We don't have an issue, Your Excellency.
No,
Many
thank you so
thanks.
much.
I'm grateful for your collaboration. You're doing good work together.
Thank you.
But if you
Thank you so
lawyers
much,
do
Your
that
Excellency.
together, yeah.
Thank you
And
so much for your direction, Your Excellency. It's highly appreciated.
thank you. Thanks
Your
for being
Excellency,
before us.
Thank you.
we are very
Good
grateful.
afternoon.
Thank you.
Thank you.
Grateful.
Bye.
Thank you.